Good afternoon. The hearing will come to order, and the chair is authorized to call a recess at any time. In the absence of our chairman, Mr. Conyers, who is temporarily detained at a meeting, I will invite our ranking member to make his opening statement in the hopes that Mr. Conyers will be here soon to give his.
Well, thank you, Madam Chairwoman, for initiating and convening this important hearing of the Task Force on Antitrust and Competition Policy. And I want to especially thank our witnesses, Mr. Barnett and Ms. Majoras, for being here today. Antitrust law affects nearly every industry. So far, this Antitrust Task Force has held important hearings on the proposed XM-Sirius satellite radio merger and the somewhat controversial issue of credit card interchange fees. Previously, the Judiciary Committee has held hearings on telecommunications, sports, oil and gas, utilities, ocean shipping, airlines, agriculture, and financial services related antitrust issues. Given the impact of antitrust law on the American economy, it is vital that we examine how well these laws are working, particularly in light of the innovation that today's high-tech economy has brought. Today's hearing gives us the opportunity to see how those laws are being enforced and whether there are any areas where congressional intervention would be appropriate. From their written testimony, it appears that last year, the Antitrust Division, the Department of Justice, and the Federal Trade Commission have both been very active. These two agencies have been involved in enforcement actions in the real estate, oil and gas, healthcare, airline, and telecommunications fields, just to name a few. Both agencies have filed amicus briefs in numerous cases before the U.S. Supreme Court in what has been one of the most active periods of antitrust jurisprudence in years. The antitrust agencies are also in the best position to assess recent trends in international antitrust enforcement, such as the European Union's recent decision in the Microsoft case, and to provide Congress with guidance on how best to promote comity between the multiple antitrust enforcement agencies around the world. Because of their activities, DOJ and FTC can also serve as a guide for this task force as it considers future hearings. For instance, I understand that the FTC has particular interest in legislation that would make certain types of settlements and pharmaceutical patent litigation illegal. I'm very interested to hear their views on this topic and perhaps possibly holding hearings on this issue in the future if needed. Again, I want to thank the witnesses very much for being here today, and I look forward to hearing your testimony later. And Madam Chairman, at this point, I'll yield back the balance of my time.
Thank you. I want Mr. Smith, if you wanted to put your opening statement in the record, or?
Yes, Madam Chair. I ask unanimous consent to have my opening statement made a part of the record.
So ordered, and all members may put their opening statements in the record. Mr. Conyers may wish to deliver his opening statement when he arrives from his meeting. I will just note that I think the antitrust portfolio is one of the most important in the DOJ. Those of us who are fortunate to live in a country that has a vigorous capitalist economy also know that competition is protected through vigorous antitrust review. And I will note that I do have concerns over the level of review of mergers that have occurred in DOJ and other enforcement activities, but I will certainly get into that when it is time for questions. At this point, I would like to introduce our witnesses and ask them to make their opening statements. First, we have Deborah Platt. Is it Majoras? Majoras, who is our first witness. She's the chairman of the Federal Trade Commission. Ms. Majoras has spent much of her career working on antitrust issues. From April of 2001 through 2003, she served first as the Deputy Assistant Attorney General and then as the Principal Deputy for the Department of Justice's Antitrust Division. Prior to her time at the Justice Department, she was a partner in the antitrust section of the Jones Day law firm. Welcome to you, Ms. Majoras. Next, we have Thomas O. Barnett. Mr. Barnett is the Assistant Attorney General for the Department of Justice's Antitrust Division. He was confirmed as Assistant Attorney General in 2006, but had been serving as the Acting Attorney General for the division since July of 2005. Prior to his tenure as Acting Attorney General, Mr. Barnett had, since 2004, served as the Antitrust Division's Deputy Assistant Attorney General for Civil Enforcement. Before joining the Justice Department, Mr. Barnett was a partner at Covington and Burling, where he was vice chair of the firm's Antitrust and Consumer Protection Practice Group. Welcome, Mr. Barnett, and if you would note the machine on the table, we have 5 minutes to hear your oral testimony. We do ask when the yellow light goes on that you have about a minute left and that you sum up, and your full written statements will be made part of the record. So first, let me call on you, Ms. Majoras, to give us your statement.
Madam Chairwoman, Ranking Member Keller, members of the task force, thank you for the opportunity to discuss the FTC's efforts to protect consumers by ensuring competition, which is a critical underpinning of our market economy, remains robust. To this end, at the FTC, we focused our enforcement efforts on the areas that are most likely to impact consumers, namely healthcare, energy, real estate, technology, and retail sectors. During the past 3 fiscal years, the FTC's competition work has produced 51 merger enforcement actions or withdrawals of mergers, which derived from 84 second requests, that is, expanded investigations, and 22 non-merger actions. During the same time period, we have completed 12 statutorily mandated rulemakings and reports, 8 public conferences and workshops, plus a set of hearings on issues arising under Section 2 of the Sherman Act, and 9 reports on competition issues significant to consumers. Through the first 11 months of this fiscal year 2007, pre-merger filings have increased 23% from the same period in the last fiscal year, and the number of investigations that we have undertaken reflects this continual uptick. Since January of this year, we've litigated 3 preliminary injunction actions in federal court. On the healthcare front last month, the Commission ruled that Evanston Northwestern Healthcare Corporation's consummated acquisition of Highland Park Hospital was anti-competitive, that it resulted in higher prices and a substantial lessening of competition for acute care inpatient hospital services in parts of Chicago's northern suburbs. The Commission also has challenged several recent healthcare transactions and achieved substantial relief for consumers in the areas of generic drugs, over-the-counter medications, injectable analgesics, and other medical devices and diagnostic services. The Commission continues to work to detect and investigate anti-competitive agreements between drug companies that delay generic entry. Indeed, our federal court challenge to an alleged anti-competitive agreement involving Ovcon, a branded oral contraceptive product, has led to the introduction of lower-priced generics. So far in 2007, the Commission has challenged 3 mergers in the energy industry: Western Refinery's acquisition of Giant Industries, unsuccessful in district court; Equitable Resources' proposed acquisition of the People's Natural Gas Company, which is still in litigation; and the proposed $22 billion deal whereby energy firm Kinder Morgan would be taken private by its management and a group of investment firms, including the Carlyle Group and Riverstone Holdings. We also charged the American Petroleum Company with illegally conspiring with competitors to restrict the importation and sale of motor oil lubricants in Puerto Rico. The FTC has actively investigated restrictive practices in the residential real estate industry, recognizing that the purchase of a home is the most significant investment that most consumers will ever make. In the past year alone, the agency has brought 8 enforcement actions against associations of realtors or brokers who adopted restrictive rules that allegedly withheld the valuable online benefits of their multiple listing services that they control from consumers who chose to enter into non-traditional type contracts with real estate brokers. In the critical technology arena, in February of 2007, the Commission issued a final opinion and order finding that technology developer Rambus, Inc. had unlawfully monopolized the markets for 4 computer memory technologies that had been incorporated into industry standards for DRAM chips. And we required Rambus to license its SDRAM and DDR SDRAM technologies according to maximum allowable royalty rates. This is the Commission's first litigated case in the standard setting area, and we believe the first time in 22 years that the Commission has heard a monopolization case in administrative litigation. The Commission also guards against anti-competitive conduct in the retail sector, and I'd be happy to elaborate on that later. In addition, complementing our law enforcement work in the past year, we've issued reports on competition issues in real estate, gasoline, broadband, and intellectual property, and provided competition analysis to policymakers regarding such areas as attorney advertising and pharmacy benefit managers. We aided the Antitrust Modernization Commission in its examination of the U.S. antitrust laws. And to ensure that our knowledge remains fresh, we are actively engaged in market research, with recent hearings examining the boundaries of permissible and impermissible conduct under Section 2 of the Sherman Act, a workshop to examine broadband connectivity competition policy, and a 3-day conference on energy markets in the 21st century. Madam Chairman, members of the task force, the FTC is committed to working to preserving competition and to protecting consumers, and we look forward to speaking with you further about this, and we appreciate your support. Thank you.
Thank you very much. Mr. Barnett, you are now welcome to deliver your oral testimony.
Madam Chairwoman, Ranking Member Keller, and other members of the task force, it's a pleasure to appear before you. I thank you for the opportunity to highlight the division's accomplishments and answer your questions. I also appreciate the active interest and strong support of our law enforcement mission that the Judiciary Committee, through the continuing work of the Antitrust Task Force, has provided to us. Competition is the cornerstone of our nation's economic foundation. Antitrust enforcement promotes and protects a robust free market economy by helping ensure that anti-competitive agreements, conduct, and mergers do not harm consumers. In my short time, I will briefly highlight just a few of our outstanding achievements. On cartel enforcement, we thank the committee for its efforts in increasing the criminal fines and statutory maximum sentences for Sherman Act offenses in 2004, as well as for making antitrust offenses a predicate act for wiretapping authority. The division's cartel enforcement efforts had an outstanding year for fiscal year 2007, which ends this week. The division more than doubled its record for the most total jail time imposed, obtained the second highest amount of fines in division history, and succeeded in obtaining the longest jail sentence for a foreign national ever charged with an antitrust offense. As one specific example of success, on August 23rd of this year, British Airways and Korean Airlines each pleaded guilty and were sentenced to pay separate $300 million fines for fixing cargo and passenger fares. Each fine ties the record for the division's second largest fine ever. On the same day, the United Kingdom's Office of Fair Trading announced a similar resolution with British Airways with a fine of approximately $250 million. This was the first time that the division and the OFT have brought parallel charges. One important focus of the division's criminal enforcement efforts in the past year has been fraud and corruption in the bidding, contracting, and procurement process. These cases take money out of the pocket of every American taxpayer and deserve severe condemnation. They deal with U.S. operations in Iraq, construction in New Orleans following Hurricane Katrina, the U.S. Navy, the Department of Defense, U.S. schools, among others. Merger enforcement continues to be one of the division's core priorities. The division is committed to challenging mergers that the evidence developed through a thorough investigation, evaluated pursuant to rigorous economic analysis, demonstrates is likely to harm U.S. consumers and businesses. In fiscal year 2007, 6 transactions were restructured or abandoned by the parties in response to a division investigation, and the division filed an additional 4 merger enforcement actions in district court. Some of our most significant recent merger actions include the following. The division challenged Monsanto's $1.5 billion proposed merger between Monsanto and Delta Pineland and obtained a consent decree that required Monsanto and DPL to divest a major seed company, multiple cottonseed lines, and other valuable assets. The division is currently litigating a challenge to a transaction between 2 daily newspapers in Charleston, West Virginia. In August 2006, the division challenged Middle's proposed acquisition of Arcelor is likely to adversely affect competition in the $2 billion tin mill products markets in the eastern United States. The division also seeks continually to improve its merger review process and its transparency. In December of last year, we announced a revision to the 2001 Merger Review Process Initiative. This initiative helps us identify and devote increased resources to those transactions that should be challenged. Our transparency efforts also have included the release of a joint DOJ-FTC commentary on the horizontal merger guidelines in March of 2006. The division remains active in other areas, such as holding hearings in conjunction with the FTC on Section 2 standards. In addition, with more and more countries adopting antitrust enforcement regimes, we make a priority of strengthening international cooperation and promoting antitrust policy convergence. In the last year, we have worked closely with multilateral organizations around the world, such as the OECD and the International Competition Network, and further developed strong bilateral relationships in other countries. I emphasize that none of what I have discussed today could have been accomplished without the dedicated career staff of the Antitrust Division. It's an honor and privilege to serve with them. I'm pleased with what we've accomplished, but I recognize that the hallmark of any successful organization is a continuing desire to improve. In that regard, we look forward to working with the members of the task force and your respective staff.
Thank you, Mr. Barnett, and thank you both for your testimony. We will now move to questions from the task force, and we will begin with our ranking member, the gentleman from Florida, Congressman Rick Keller.
Thank you, Madam Chairman. And Ms. Majoras, let me begin with you. I know you only had 5 minutes to give us your opening statement. One of the things you weren't able to expound upon was some of the work you do on behalf of consumers in the retail sector to tackle anti-competitive behavior. Let me begin by asking you if you had a chance, you or your staff, to observe the hearing that this task force did in July on the issue of credit card interchange fees and the impact those have on the retail sector.
Thank you, Ranking Member Keller. I know that we followed the issue with some interest. I will say this, though: the Justice Department and the FTC try to divide our work, and I hate to do this on the very first question, but the interchange fee issues have traditionally resided with the Department of Justice, and so they have brought cases in the area, and so we're less informed on the issue.
Okay, and Mr. Barnett, let me ask you: was that a hearing that you were able, or your staff was able, to observe? And is there anything that your office is doing to take a look at this interchange fee issue and the impact on the retail sector and consumers?
Yes, we are very focused on this issue. It not only through events such as the hearing, but through conducting our own monitoring activities and investigations in the area. Without commenting on any specific investigation, I would observe that these markets are somewhat complicated. They're what our economists like to call two-sided markets, which makes the analysis of competitive effects and the impact on consumer welfare more challenging than some other areas. Notwithstanding that, that's a challenge that we think it's a very important area of the economy. It's an important sector, and so we are looking at it. We have significant resources devoted to evaluating that issue right now.
Well, thank you. And it's also a two-sided issue, as you know, and certainly the credit card electronic payment system has revolutionized the world and made it easier, and we're all thankful for that. And then on the other side, we hear the retailers telling us, hey, this is 60% of the market share, MasterCard and Visa, and they can charge us as much as we want, and there's nothing we can do about it. So we're actively looking at both sides as well, as you are. While I have you there, Mr. Barnett, let me ask you, we had a hearing back in February on the XM Sirius satellite merger. Were you or your staff able to observe that hearing and the testimony of our witnesses, such as the CEO, Mel Karmazin?
Certainly, Ranking Member Keller, any transaction that for which we are conducting a full-fledged investigation, and that is certainly a transaction on which we are quite focused in conducting an extensive evaluation, we try to obtain information from wherever we think we can that will be useful to us, and information through hearings such as the one as this committee held, having industry participants providing testimony is very relevant information.
And I don't want to cut you off, but my time's running out, so let me just do a follow-up and give you a chance to answer it. I know there's some things you can't talk about, and I'm not going to ask you what your decision is going to be or what your thoughts are, but can you give us an idea of the time frame for whatever decision is ultimately made and what the status of this review is right now?
I can't, I'd like to, but I can't give you an exact time frame. We want to make sure that we get the information that we need so that we can conduct an appropriate analysis and evaluation, and we will not decide until we've done that. We want to do that as quickly as possible, but we also want to get to the right answer.
Thank you. I have several more questions, but my time has expired, Madam Chairman, so I will yield back the balance.
Thank you, Mr. Keller. I want to follow up on the credit card interchange fee issue because the hearing that we had was really pretty stark, and it became pretty clear in the course of the hearing that this is a very one-sided operation where the retailers, in some cases, they weren't even permitted to see the contracts, and they're very high fees. I actually was so frustrated at the apparent lack of action in DOJ that I contacted the Attorney General of California to see, states have an opportunity, and they're actually having active investigation ongoing on this issue. I'm wondering, if you can't tell us obviously what you're going to decide, what is your estimate on the time frame for your investigation of this situation? Can you tell us that, Mr. Barnett?
Again, I don't have a precise estimate. I can tell you that we tried to be thorough and comprehensive in our evaluation. To give you an example, when the division brought an action in the credit card industry against involving Visa and MasterCard, that investigation took a number of years before we had collected the information that we felt was necessary to pursue the challenge. We then filed a suit and ultimately prevailed. This is a much more recent investigation. I expect that it will take us some time, but again, we like to do these as quickly as we responsibly can, and that's what we're committed to do here.
May I ask how many investigators you've assigned to this?
I don't have an exact number here.
If you could get back to us on that, I would appreciate. Obviously, we want a thorough investigation, but how much effort you put into something also depends on how fast it's going to be done. And in the meanwhile, if the testimony we received is correct, there's a lot of retailers in the country that are being on the short end of the stick, and consumers paying higher prices than they really should.
Well, Madam Chairwoman, it's a little difficult for me to give an exact number in that the number of people involved at any given point in time varies depending on what is going on in the investigation. If we're
perhaps you can give me a range,
deposition.
How many and over what period of time. I want to talk about standard setting. You mentioned, I don't want to get into individual cases, but in the tech world, it is a difficult matter. You do want standard setting. That really does advance the growth of technology. On the other hand, you can have problems with standard setting, as we all know. And I know that the joint IP report that you have issued indicates that the agencies are going to evaluate joint ex-ante activity to establish licensing terms under the rule of reason. Have you been able jointly to do that kind of follow-up and tracking of these standard setting operations, and if so, what have you found?
We are continually monitoring various developments in different industries. The division has issued a couple of business review letters, one involving VITA, an organization called VITA, the other one I believe IEEE, where we applied a rule of reason type analysis to some disclosure policies that those organizations were interested in pursuing to try to address the issue of what some people call sort of hold-up issues. After they set a standard, a member who has a patent
right. No, I'm familiar with the issue.
In those instances, we found that under a rule of reason type approach that the disclosure policies were reasonable and we thought would be potentially pro-competitive.
I'm wondering, time is almost up, whether you can explain to us, maybe in a follow-up letter, how you go about tracking this, as you said you would in the report, and whether it's pursuant to the National Cooperative Research Act, and if you have a comment on how that has worked in terms of spurring this kind of disclosure, it would be very helpful. I know Ms. Majoras, in the remaining seconds.
Very happy to do that. We've been very active in the standard setting arena, and we are monitoring complaints and so forth as we get them from standard setting organizations, so we can absolutely give you a follow-up on that.
I would appreciate that. My time has expired with actually 18 seconds to go, and so I will now call on the gentleman from Ohio, Mr. Shabbat, for his...
Thank you very much, Madam Chair. And I'd ask the first question to either or both of the witnesses here. The Antitrust Modernization Commission made a series of recommendations regarding the Hart-Scott-Rodino Act and the merger process as it relates to the roles and responsibilities of the FTC and the Department of Justice. What have you done to facilitate the implementation of these responsibilities, particularly as it relates to prompt clearance to either the FTC or the Department of Justice, and parity among the FTC and Department of Justice enforcement mechanisms? And you can both take a shot at it if you'd like.
All right. Well, before the AMC even issued its recommendations, we had already been working on those things. The issue of burden in the merger review process is one that's been with us for years, and one that I've been particularly interested in, both in the private sector, at the DOJ, at the FTC. And so in February of 2006, we put into place some new measures to try to curb the burdens in that process. Some of those match pretty completely to the AMC recommendations. Some of them don't. A few of the AMC recommendations we don't necessarily agree with because we think it's such an effort to micromanage the process that in the realities of trying to do a merger investigation, it would inhibit our abilities. But we're trying very hard to curb the burden because, frankly, it puts a lot of burden on us as well. The second thing on the clearance issues, we have currently, this issue has been with us for years. We've tried to fix this. How we allocate the work between us. We're trying again. We have people from both agencies sitting down, working together, and trying to come up with a new system. But some people in the bar, of course, in the business community, think that Congress, we should work with Congress to actually make a division.
Okay, thank you very much. Anything you'd like to add, Mr. Barnett?
Just quickly on the burden of the review process, the division back in 2001, frankly, when Chairman Majoras was at the division, launched a review process initiative that was designed to reduce the burden, increase the efficiency. That has worked very well. We nonetheless updated and revised it a bit in December of last year. Overall, we think we're more successful in clearing transactions without having to issue a second request, identifying them early as not a threat to competition. And we continue to work in that regard because, as the chairman says, the vast volumes of information and documents that we receive are a burden on us as well as the parties. On clearance, I readily endorse what the chairman said. We are working on it, have been. We have people working on it right now, and we're committed to trying to improve that process as well.
Thank you very much. My second question is, what are the implications of the increasing globalization of antitrust law? Does America's view of antitrust law, that it seeks to protect competition, not particular competitors, hold true in other jurisdictions? And should America be promoting its view of antitrust laws abroad? And if so, how should we do that? And again, you can both take a shot at it.
Sure. Well, there are two sides to the coin on this one. On the cartel enforcement front, the globalization of enforcement has been a benefit to the United States. It's made it easier for us to detect, gather evidence about, and prosecute cartels and those that prey upon American consumers. So that's been and the example of the OFT going after BA at the same time we did is a good illustration of the benefits. With respect to mergers and other kinds of conduct, there are challenges that are there, that having different approaches, different processes can create burdens. Having divergent outcomes can create very significant concerns. And both agencies have been very focused on this for years. That was part of the purpose of the agencies helping to found the International Competition Network in 2001, and why we are so engaged through organizations, through bilateral relationships, why we've sent people to China, who's been recently enacted an anti-monopoly law. It is a concern, and it's one that we are trying to address.
Thank you. Ms. Majoras?
Thank you. There is no question that we, in our work internationally, and that includes with developed countries, so our major trading partners, but also with developing countries who now have antitrust agencies and are trying to develop market economies after years of having state-based economies. So we're doing work with all of them. And yes, we definitely are trying to influence the process by what we've learned that we've done well and that we haven't done so well in enforcement of antitrust over the years in the United States. So that's clearly a big part of what we're doing. It's a challenge. In 1990, we had about 25 competition agencies worldwide, and today we have over 100. So it's a lot to absorb into the competition group, if you will, in a short period of time.
Thank you very much. I think my time has expired, Madam Chair. Thank you.
Thank you. The gentlewoman from Ohio, Ms. Sutton.
Thank you, Madam Chair. Thank you both for your testimony. You made it clear in your remarks that in the United States, the antitrust divisions of the Department of Justice and, of course, the FTC review various mergers and acquisitions to consider whether they have anti-competitive effects. And this sort of follows up on my colleague from Ohio's questions. So when a major hospital or hospital firm or a bank seeks to acquire another, we consider here in this country if the merger would put any single player in a market in a position to manipulate the market. But while antitrust considerations apply to U.S. firms, we are now, as you point out in your testimony, living in a global world. Trade agreements, starting with the 1994 NAFTA and the 1995 WTO, contain various service sector market access conditions that provide the right for foreign firms in covered sectors, to establish and operate in the United States through mergers and acquisitions and startups, et cetera. And the market access rights for those foreign firms established in the WTO's General Agreements on Trade and Services and the NAFTA and CAFTA and other free trade agreements, including the one that will be voted on shortly here with Peru, it guarantees such market access rights free of government limits on the size of the firm, the number of employees. The United States has submitted its own hospitals, insurance, banking, and other financial service sectors to such commitments. So I have a couple of questions. I mean, can you tell me what would happen when a foreign firm already operating with a sizable market in the U.S. then sought to acquire another large U.S. operation in the same sector? And wouldn't those extreme service sector market access rights for foreign firms in our trade agreements conflict with our own domestic antitrust policies?
If I understand the question, or my understanding at least is if a foreign firm has operations in the United States and they seek to acquire another United States firm, that transaction would be subject to Section 7 of the Clayton Act and Section 1 of the Sherman Act, and we would review it. And if we found it constituted a violation of the law, we would pursue it. I'm not aware of there being a trade barrier or a bar to our pursuing such a transaction.
Indeed, I would just add that today, despite what trade agreements say, if a foreign firm that operated in the United States and sold goods to our consumers wanted to merge with another foreign firm that also had sales in the United States, and that were to present a competitive problem, we could go after that merger as well. So, so I agree with Mr. Barnett. I don't see that as raising a problem for our enforcement.
And has that happened at all? Have you gone after any foreign firms?
Sure. I'm trying to think of particular examples. I mean, we required, certainly, for example, we had British Petroleum take over Amoco some years ago, and the FTC required major divestitures in that particular case.
I would give the example of Mittal Arcelor last year, two steel companies. Mittal is, well, Indian but based in Europe, and Arcelor, the target, is a French headquartered company. They both had operations in the U.S., and we sought and obtained a significant divestiture to remedy competitive harm in the United States.
Okay, just so I understand correctly, you're saying that all of our antitrust policies can be applied to foreign firms operating in the U.S.?
That's essentially how the jurisdiction works. Obviously, there's legal terms for exactly how it works, but foreign firms operating in the United States that sell goods here, we've not had a jurisdictional problem in attacking practices when necessary.
Are you consulted when the United States is negotiating the trade agreements to make sure that there aren't any conflicts?
We not only are consulted, but we, particularly with some of the recent trade agreements, there have been competition chapters or sections to it. We have been active participants. We've been at the table to help guide those negotiations, and generally think they've gone quite well.
And both of you?
That's correct. Both agencies together with USTR and Commerce.
Okay, great. Thank you. I yield back.
Yields back. I'd like to recognize the gentleman from California, Mr. Lundgren.
Thank you very much, Madam Chairwoman, and thank the witnesses for appearing. This may sound like a strange question coming from me, but when we talk about we applaud the globalization of the antitrust concept and that we attempt to influence or exert our influence as we can effectively for other countries to adopt the same approach, I wonder how you respond to the question from some other countries about the multiplicity of authorities that can handle antitrust cases in the United States. Not only the two of you, but as a former Attorney General of California, we jealously guarded our authority. We attempted, I thought, to try and work with the Justice Department, particularly the U.S. Justice Department, to ensure that we were working in concert and didn't sort of double up in inconsistent ways. But if we were to look at a foreign country and we were to look at them with a regimen for antitrust law, or call it what you will, that appeared to have a multiplicity of authorities to which American companies would have to respond, and in some ways just the time it would take to go through the multiplicity of authorities would delay our entry into the marketplace or our effective way of doing it, we might take umbrage at that. And so my question is, can you give us an idea of how you would explain the legitimacy of having multiplicity of authorities, how you attempt to ensure that that does not inadvertently add uncertainty to the economic decision-making that really doesn't go to the core of antitrust questions, but to the core of decision-making?
Terrific question. One that we do grapple with. We've been asked many times. I can remember very recently in China being asked very specifically about why we have two antitrust agencies and how that all works. And to tell you the truth, my response is that if you were starting from scratch, you might not do it this way. I think our system's working very well today because we've adapted it, but one has to ask the question, how many layers of enforcement do you need? Because, of course, the problem with over enforcement of the antitrust laws is the market starts to freeze up as heavy regulation does in other contexts, and so suddenly the very competition that you want to protect, you are squelching instead. And so we talk about that. We talk about how we work together with each other, how we worked with sectoral regulators like the FCC, how we work with the states, and how private enforcement works, and some of the ways in which private enforcement, which Europe is now looking at, might be done in a way to avoid some excesses.
I completely agree with that, and would just add briefly that it does present potentially a very significant burden and obstacle to marketplace competition and efficient operation of the markets. I think it's incumbent upon the various antitrust enforcement authorities, for example, the FTC, the DOJ, and the various state attorneys general, to coordinate and to cooperate in a way that minimizes those burdens. And one example I've given is if we're going to pursue a joint enforcement action or a joint investigation, it should appear to the parties as if there really is only one investigator and one prosecutor. That's the ideal situation to try and minimize that burden. But the potential for harm is very real.
Ms. Majoras, let me just ask you a question on a particular case. The FTC recently had the case of the proposed merger between Whole Foods and Wild Oats grocery stores, which was unsuccessful in federal district court. But in your written testimony, you indicate that the Federal Trade Commission is still pursuing an administrative action against Whole Foods. Can you explain that? Because from the outside, it would appear you lost in court, but it's like, okay, we lost there, but we still got you.
Of course. The way the Congress set up the FTC, when we believe that a merger would be anti-competitive, we file an administrative action within the FTC. But in order to stop the merger long enough to be able to proceed in administrative action, we go to federal court for that purpose. That is different from the Justice Department. Right. Where we are now is, if we've lost in district court, which we have, the next step will be to decide whether, in fact, we will go forward and administratively. I mean, it's there now because it was filed months ago. The question now is whether we'll proceed. The Commission has a test that it goes through in deciding that, and it's been the very rare case that we have proceeded after losing in district court.
Thank you very much. Thank you, Ms.
Gentleman's time has expired. The gentleman from Utah is recognized for 5 minutes.
Thank you, Madam Chair. If I could just follow up with both of you briefly on Mr. Shabbat's line of questioning to some degree, Mr. Lundgren's. Could you describe what we are doing with especially the European community to harmonize our laws? Do we have a process, and how aggressively are we pursuing that?
We have a very extensive process at multiple levels, both at the European Commission level as well as at the member state level now, because most of these member states have their own regimes and indeed enforce not only their member state laws, but also European competition laws. We have annual bilateral consultations with the European Commission. Our staffs communicate on virtually a daily basis on individual investigative matters. Where there are issues of concern that come up, it gets elevated, and either at both agencies, I think we speak directly to their senior management on those issues. We also work through multilateral organizations such as the OECD or the ICN, publishing best practices, as an example, in merger review that helps persuade those organizations, including the European Commission, to improve their processes. And, you know, on the cartel enforcement front, as an example, we've been very active with the European Commission as well as the OFT and some others on working on their enforcement programs.
Thank you. The FTC is currently reviewing the proposed Google DoubleClick merger, and my understanding is that it took the FTC and DOJ more than the entire 30-day period under the Hart-Scott-Rodino pre-merger notification process to determine which of the two agencies would review the merger. Why did this take so long, and would DOJ and FTC and ultimately the parties themselves benefit if Congress were to allow you to enter into an agreement similar to the agreement you had in 2002 that helps spell out which mergers would be reviewed by which agency in advance?
Yes, I think we would be benefited. I was at the Justice Department at the time. We negotiated that agreement with the FTC, where I now am, and it was an effort to fix this problem. And we were, some members of Congress asked us to stand down, and we did so. But I think to the detriment of the system overall. Why did this one take longer? Unfortunately, in higher profile mergers in interesting markets, first of all, they tend to be converging markets, so it's not clear which of us has the best experience. And then our staff are eager. They like to, they're interested in what they do. And so we have a big back and forth over who has the most experience and who ought to get the matter. I'm not proud of the process. It embarrasses me, quite frankly, and I've been talking about that for years. We've tried to make as many internal reforms as we can, but during my confirmation hearing, I was asked to please refrain from going back to the 2000 agreement, and I agreed to do it. So I think it would take some action from Congress before I could do that again.
Let me try and get one last question. I had a startling experience this last week. I have a 9-year-old who is now old enough to have a telephone, and I have a son who just returned to the United States, and so in the last month or so, I've purchased 2 telephones, and I noticed that you, in the other body, talked about the common carrier exemption frustrating the FTC's ability to deal with deceptive and unfair acts. Is that the case? And in particular, this is a complex area of law. I used to chair the Committee on Commercial and Administrative Law. Now I'm the ranking member there, and clearly there are some commercial aspects here of contracts of adhesion. But with my son, it was fairly straightforward. I had to ask about the $175 termination fee, which I'd read about elsewhere. That was with my daughter. With the most recent phone, we went through this elaborate process where I signed documents that I didn't have time to read, didn't have an interest in reading, and then had to take a phone call from the company where I agreed to certain terms, but none of the I didn't think the significant terms. And finally, the phone didn't get qualified until they sent me an email or a text message, and I responded to the text message. I'm amazed at the process. I mean, what you have here is a convergence of many carriers on several items that cost consumers a great deal of money. Is that what's driving your concern?
What's driving our concern is that with the convergence of technologies and the like, and when new technologies come up, consumer expectations aren't necessarily set. So consumers need very good disclosures about what they're paying for. Here are markets in which if the company claims that they have common carrier status, it's true the FTC has no jurisdiction, so we can't assert our authority to battle deceptive practices. So yes, that is what we're trying to get at.
This is an amazing thing where poor people are way disproportionately affected by these harsh decisions. I think there's now a universal deal that you can't terminate a contract even one day before the 2-year period runs without incurring a $175 fee. I would encourage you to pursue that. And if we need to help with some kind of change to the law, I'd like to know that.
All right, thank you.
Gentleman's time has expired. The gentleman from Indiana, Mr. Pence, is recognized.
Thank you, Chairman. Thanks for calling this hearing and bringing these 2 distinguished public servants before this task force. I appreciate your service to the country. And curious about a couple kind of headline issues and what either one of you might be doing with them. Number one would be, when I'm back in Muncie, Indiana, people are not much worried about some of the issues we fight about out here, but they're pretty worried about gasoline prices. And to the chair of the FTC, I'd ask, there's calls for regulation of the oil and gas industry here in Congress. Price gouging statutes have been advanced. I haven't supported them, but I mean, as federal solutions. I know the FTC has looked at this, and I'd love to know what has the FTC actually found at this point with regard to collusion and the pricing of gasoline. And secondly, also ripped from the headlines, Mr. Barnett, is this whole issue of real estate, mortgages, and the concern that we all have about when all these ARMs come due at the end of this year. And I know that the Antitrust Division under your leadership has undertaken a civil action regarding real estate broker activities, and just wondered if you might comment as appropriate on that and how you think that kind of enforcement will benefit homeowners in the future.
We are well aware at the FTC that there's virtually no product in the United States that's sold that affects consumers as much as gasoline, and certainly the price of gasoline, which has gone up in recent years. So we spend an enormous amount of time studying gasoline markets, investigating gasoline markets, and making sure that that companies are adhering to the antitrust laws. We have done several studies in recent years, including a major study after Hurricanes Katrina and Rita. We have not found collusion among the oil companies. Obviously, we have OPEC at the upstream end, which is another story. But we've not found it. what we have found, which is hard for people to hear, is a market that behaves pretty competitively according to laws of supply and demand. Now, in recent years, demand has been going up. Our supply has not kept pace. People ask, well, how could that happen? How could there be competitive markets, but our refining capacity is not keeping pace? Well, the problem has been, and we sort of have short memories, I'm afraid, that it was just a few years ago that refineries were not making so much money. Their profits were not going up, and so that inhibited investment. What we're seeing now, and we just saw a major announcement by Royal Dutch Shell, that in fact they are increasing their capacity in Port Arthur, Texas, by 325,000 barrels a day, which is enormous. That's a third of all of our imports that we get. So we're seeing what we thought we would see with these higher prices, increased investment, and we think that that's going to be a good thing for consumers.
And British Petroleum was trying to increase its capacities in Indiana until very recently.
Yes, indeed.
Be very aware.
So it's a big area, obviously, of discussion. I'd be happy to talk more, but I don't want to use up all your time.
Very good. Thank you.
Well, if there is any one market that's as important as the gasoline market, it might well be the real estate market, given that that is by far and away the largest transaction that most people engage in their lives. I don't think it's appropriate for me to comment on pending litigation, but
Understood.
more generally, but the Department of Justice, and very much in cooperation with the Federal Trade Commission, has been quite active in the real estate area. It's not only through investigations and enforcement actions, such as a couple of years ago when we took an action against the Kentucky Real Estate Commission, which banned rebates by brokers, essentially banning price discounts to brokers. We've been engaged through advocacy efforts with a variety of states who either have regulations or laws that ban such price discounting or that are considered to do so, as well as something they called minimum service requirements. That means they force you as a purchaser of brokerage services to buy a package of services even if you don't want all of them. And we have found that by freeing up the market to let consumers and suppliers make these choices, there's indications that consumers can save thousands of dollars on a transaction, which is a very significant benefit to Americans.
Thank you, Chair. Thank you, General. Yield back.
In consulting with the ranking member, we are going to do a quick second round of questions. Not that everyone has a second round, but Mr. Keller, I think, has a quick question. I know I do. So Mr. Keller is now recognized for 5 minutes.
Well, thank you, Madam Chairman. Mr. Barnett and Ms. Majoras, you know, here in Congress, we essentially have two types of laws. One, the non-controversial laws that we can all agree on bipartisan basis. We pass those in the House through the suspension calendar, and the Senate has a procedure called the hotline. And then the controversial laws, which are the ones that grab all the headlines. I want to start with non-controversial laws and ask you, as people who deal with the antitrust issues on a daily basis, far more than members of Congress do, is there any sort of non-controversial technical changes to the antitrust laws that you feel would be helpful and would be needed to help you protect consumers or to otherwise do your jobs? Mr. Barnett, I'll start with you and give you both a shot at that.
Short answer is, I think, no. We do, and I don't know if you call this controversial or not, but I want to underscore our gratitude for the 2004 Act that you all worked on to increase the statutory maximum for fines for criminal cartel price-fixing activities. The effects of that are really only just being felt now, and we're optimistic that we're going to see very significant increases in actual penalties imposed, and we appreciate your efforts in helping us get there.
Okay. Ms. Majoras, any thoughts along those lines?
I can't, Congressman Keller, I can't think of anything off the top of my head, but if I may I think about that a little bit and submit something to you in writing if we think of it?
Yeah, please get it to me
Great.
and also Chairman Conyers. And then let me just follow up with the second part of that question. Is there any law that might be considered controversial by some sector or another that you all think that nevertheless would be good for consumers or otherwise would be helpful for you to do your job? And what comes to mind, Ms. Majoras? I know some folks at the FTC I've heard support legislation that preserve access to Affordable Generics Act, or I'm not really up on it, but something to do with settlements and pharmaceutical patent litigation that may may be illegal, or I understand that's controversial, but along those lines, and let me again start with Mr. Barnett. Any big ticket laws that you think that should be proposed or considered that might be controversial?
Well, I would mainly point to one recommendation of the Antitrust Modernization Commission, which in my testimony before them we supported, which is a reevaluation of any antitrust exemptions that are out there. We do believe that not only should they be rarely passed, but they ought to be periodically reevaluated to see that the conditions that may have justified them at one point in time are still warranted.
Even baseball?
I'm not going to take anything off the table.
We're going to make headlines. Let's swing for the fence here.
Yeah, there you go.
All right, Ms. Majoras?
As you mentioned, we've been in discussions with some members of Congress about an issue that has concerned us for some time, which is the issue of branded pharmaceutical and generic pharmaceutical companies entering into settlements together where the branded pays the generic to stay out of the market for a particular period of time. It's a complicated issue, I will grant you, but we and our economists have looked at it, and we actually think that consumers are being harmed and that it's not just a matter of exercising patent rights in a legal way. So we have been very concerned about that. The Antitrust Modernization Commission has recommended that the Robinson-Patman Act be repealed. I think it's something that's worth taking a look at. I think that statute has probably seen better days, and it's as we talk about the international realm that we find ourselves in, that act is put in our faces constantly as a measure that was put in place years and years ago to protect small businesses. We know a lot more now about what it takes to have a vibrant marketplace that even includes small businesses, and I don't think the Robinson-Patman Act is something that is protecting consumers as it was intended to.
On the pharmaceutical end, real quick, are you suggesting any changes to Hatch-Waxman?
I'd rather see the change in Hatch-Waxman than see the change in the antitrust laws. But there's no question Hatch-Waxman created this situation, no doubt about it. It was an unintended consequence of Hatch-Waxman, which of course had a very good purpose in both protecting branded intellectual property so they could get return on investment, but at the same time making sure that affordable generics come into the market as appropriate. So this has been caused by Hatch-Waxman. So if we're going to act, I think that's the way to do it.
Thank you, and Madam Chairman, I yield back the balance of my time.
The gentleman yields back. I just have a couple of quick questions. I will note that, as I said in my brief opening remarks, the antitrust portfolio is an essential one, and I have had the sense over the last several years that the enforcement has, at DOJ at least, has not been as vigorous as it has been in past years, and the statistics seem to back that up. Using the Department of Justice's own statistics, there was a 59% decline in merger investigations in the past 4 years of the Bush administration compared to the last 4 years of the Clinton administration. And with respect to merger challenges, in the last 4 years reveal a 75% decline compared to the last 4 years of the Clinton administration, and a 37% decline even for non-merger enforcement. There are times when I feel that the most vigorous antitrust activity is really occurring with state AGs, but there are some things I think that it's very difficult for them to do, and that really comes to my question regarding the Internet. I believe that the rules that were in place until the FCC decisions in 2005 really did play a tremendous important role in fostering innovation and an even playing field in that section. And I was very surprised, frankly, that the department submitted a filing with the FCC just recently and late opposing the concept of net neutrality. And I was wondering why this filing was months late after the comment period was over, and what motivated the department to do this, and who did you meet with? I note in the filing there was a mention of the opponents of net neutrality hands off the internet and consumers for cable choice, which I think are sometimes referred to as AstroTurf groups, really funded by the phone companies, AT&T and Verizon. I'm wondering, did you meet with the opponents of the phone companies before you filed? Who did you meet with in reaching the conclusion?
Well, Madam Chairwoman, I respectfully disagree with your assessment regarding the DOJ's enforcement activities. With respect to merger enforcement, we applied consistently across, believe across administrations, the horizontal merger guidelines that both agencies.
Oh, my question was about the net neutrality filing.
I understand that, Madam Chairwoman. I just note that between the last 4 years of the Clinton administration and the last 4 years of the Bush administration, there was perhaps a 70% drop in the number of mergers, so you would expect the number of reviews and the number of challenges would likely to go down. With respect to net neutrality, I was the one who made the decision to file those comments. We certainly collected information from a wide range of sources.
Can you give me a list after this hearing?
The gist of the comments, or the bottom line, is not necessarily to say that some form of regulation is ever inappropriate. It was to say that as we understand it, and this is a core part of our competition advocacy mission, as we understand it, in general, we let markets work with antitrust enforcement as a backdrop. We try not to intervene with government regulation unless there is a specific case to be made for that. And we had not seen, until we reviewed the other comments that had been filed with the FCC, we reviewed them and we did not see that a case had been made. Doesn't necessarily mean that a case can't be made down the road, but we were providing our experience, our expertise in this industry for the benefit of the FCC.
I would like to know, and you can provide it in writing afterwards, I don't want you to orally list it, but I would like to know who you met with or who the department met with prior to that filing. And I also would know, because my time is about to expire, that 96% of the residential broadband market nationwide is really controlled by a duopoly, and I just can't think of why that wouldn't be a compelling public policy goal to disrupt that kind of market control, and how you can possibly think that that is a competitive market. It's just astounding to me. So I will not belabor it. I will look for your report on who you met with after this hearing, and I will now call on the gentleman from, I guess our gentlemen have left. My time has expired, and Ms. Sutton has left, and I guess we've closed down this hearing. At this point, we will note that the hearing record remains open for 5 days. Members have 5 days to submit additional questions, and we would ask the witnesses, if we forward additional questions, to answer them as promptly as you may. And with that, this hearing is adjourned.
Thank you, Madam Chair.
Thank you.